Inheritance is a critical component in ensuring that one's legacy is being honored and that loved ones are being supported after death. A will is an essential, or a will plays an essential role in this process, and a will provides clarity and also minimizes conflicts. Good evening, televiewers, and thank you for joining us on this edition of the program Issues on Divine Mercy Radio Television. In the course of today's program, we shall be looking at the right to inheritance and the will. Our guest will be joining us to tell us whether or not children have an automatic right to the properties of their parents after they die. And then we are also going to be finding out the importance of a will and why so many persons neglect writing a will. You can join us in the course of this discussion. We shall be coming back right after the break. The right to inheritance and the will. What is your opinion? Joining us on set today, we have a barrister who is right here with us and who is going to be sharing with us her expertise as far as this topic of discussion is concerned. Barrister Mrs. Walang Onori, you're welcome to the program.
Thank you, Mirabel. Good evening, televiewers. Good evening,
Thank you for joining us on this edition of the program, and we look forward to learning from your knowledge. We are also welcoming on board Mr. Mba Tebo. Mr. Mba, how are you?
I'm fine. Good evening.
Good evening and welcome to the program.
Thank you very much.
Now we are looking at the right to inheritance and the will, and so it is good for us to have an understanding of what inheritance is as peculiar to our context, to our country, and Barrister is going to be helping us with that.
Okay, so far as the right of inheritance is concerned in Cameroon, the right of inheritance is governed by combined customary law, statutory law, and Islamic law, depending on the context. When it comes to a Cameroon legal system, we have a dual legal system.
Okay.
That is, we have the French, the civil law that governs the French part of Cameroon, and we have the common law that governs the French part of Cameroon.
The English part of Cameroon.
The English part of Cameroon.
Okay.
And so far as both laws are concerned, they encourage the right of inheritance for both male and female in Cameroon.
Okay.
And we equally have the Islamic law that govern the Islamic communities, which is the Sharia law. The Sharia law, so far as inheritance is concerned, they give priority to the male child. The male child has a large part of the inheritance as compared to the female child.
Okay. So we are talking about the dual law in Cameroon.
Yes.
Tebo, I know you are not going to be telling us about the law, but you're here in the capacity of a child and in the capacity of a parent. Now, when it comes to inheritance, what runs through your mind?
Once again, good evening, televiewers. I think that excuse me. I think that when it comes to inheritance, what goes through my mind is the handing of property from father to the children, or handing of property from father to the sons, depending on how you want to see it. Maybe what the father is left behind, both property and debt. I think both asset and of course inherited debt. So I think it's a common thing in our country. I think that apart from the the legal cover which goes with it. I think inheritance is some kind of institutionalized within our different culture, within our society, within our villages. People just have to, people know that when this person dies, automatically the children inherit the property even without a written will. I think this in the past had led to a lot of conflict in some communities with extended family members coming to fight. But generally speaking, inheritance is something which is understood by everybody, which is respected in different, which is respected in all the cultures. It is true that some cultures have some peculiarity in terms of who takes what when the father or the mother is no longer there. But I think there is no denying the fact that everybody understands in all communities that when the father or a mother or the head of a family dies, somehow the sibling or the relatives directly inherit their
properties. Okay, now you spoke about the transfer of property from the father maybe to the children, but you didn't talk about the mother. Is it that women don't own properties?
I said both father
and mother. Okay, thanks for that clarification. Now let us look at the will, because the two go together. They have told us that the will is very important in the process of this transfer. Now let Barrister tell us, what is a will?
A will is a true declaration of a person declaring how his properties will be shared or will be distributed when he's no longer alive.
Okay.
Yes, that's a simple definition of a will. And a will is term ambulatory, because this term is used for a will because a will can only get into effect after the death of the person who is writing the will.
Okay.
And the person who is writing the will is known as the testator.
Okay.
Yes. So as we are talking about the will, you hear me calling somebody testator.
Okay, who is the person who is writing the will.
And if a person dies leaving behind a will, they use the term that the person died testate.
Okay.
But if a person dies without leaving a will, it's known as intestacy. Or he dies without leaving a will.
Okay.
So this term is good to make clarification when we are talking about the will, so far as these terms are concerned.
Okay.
Yes.
Now, we used to hear that someone will say before this pa died, he said that he told this brother that.
Verbal will.
Yes. Can we have a verbal will, or a will must be written? An authentic will, must it be written?
Yes, for a will to be authentic, it's always good to be written. But there are other wills that cannot be written, depending on the situation. For instance, in a situation where a soldier is at the war front, and he's about to die, yes, just the words of his mouth
stands as the will.
Stands as his will.
Okay.
But in a situation where somebody really intends to put down something as a will, it's always good that the will should be in writing.
Okay.
And the person signs the will. And it's good that the will should be notarized. Our legal practitioners, they have the right to notarize our will, even though it is not mandatory.
Okay.
But to make it to be legally binding, and to stand the way that the will
deserves.
It's good to always involve a legal practitioner to authenticate the will.
Okay, which means that if someone writes a will today and just keeps it maybe under the pillow or somewhere in the house, that will can be contested as not having the legal backings.
It depends on where the person keeps the will.
Okay.
I said from the beginning that authenticating it gives it more weight.
But it doesn't cancel
the fact that
that is a will.
So far as it is in writing, it is considered to be somebody's last wish. And if his signature is appended to it, and if he signs the will in the presence of two witnesses present at the same time, yes, and the witness is also authenticated.
Now let me just stay with you. I want you to tell us, just tell us chronologically the process of establishing a will.
Okay, the process of establishing a will. First, the testator, that is the person writing the will, he has to first pen down the will, that is to write the will. After writing the will, he has to sign the will.
Okay.
and he signs the will in the presence of two witnesses who are present at the same time. And when he writes the will and they sign it, he has to keep the will in a safe place.
Okay.
After keeping the will in a safe place, now, after his death, if he appoints executors, the executors now will take the will, and
Are the
and follow up.
executors the same as the legal practitioners?
No.
Okay.
Executors are people who have been appointed by the testator. Remember at the beginning I said a testator is somebody who is writing the will.
Exactly.
So the executor is somebody who is being appointed by the testator. That is the person who wrote the will before he died.
Okay.
That
If I die.
this person should be the executor.
Okay.
In a nutshell, this person should be the one that will manage what I have.
Written.
Yes, what I've written.
Okay.
So now, after keeping the will in the executor will take the will now to the probate division of the High Court, and you will register the will with the registrar of the High Court of the probate division. And then now, the executor has to go there with an application that the will and attach the will to it. If the court goes through the application and sees that all the modality
Were
have been
followed.
met, yes, and the will is a valid will, now the will they'll grant now the probate, they'll grant now the right to the executor or executors, because the testator can appoint as many executors
As possible, okay.
depending on the extent or the properties that he has. So now they'll grant now they'll effect the will to probate. That is giving the rights now to the testators or the executors. I mean the executors to share now the properties.
The properties.
Yes, the property in the will.
Now, let me just get a clarification, because you're talking about a testator who is someone who is writing the will, and that person appoints an executor. Can the testator, let me say if I'm writing a will, can I not go straight to a lawyer and say, okay, this is my will, I don't need anybody, maybe in the will there is someone who is going to handle that part of ensuring that things are being distributed the way they should?
Yes, you involve the legal practitioner
Okay.
to make the will to be more valid and authentic and
Okay.
concrete,
Okay.
and in such a way that the testator, the legal practitioner will actually guide you on the various steps that you really
You need
have
to
to
follow.
you need to
Okay.
follow. But now the executor is there, who that at times is the executor is different from the legal practitioner.
Okay.
The legal practitioner is there to give the legal advice, and the executor is somebody that you have appointed.
Okay.
And I want to make this clarification here that it's always good that the executor should not be signatories to the will, because if they are signatories to the will, it creates some sort of conflict.
Okay.
And at times, when you are a signatory to a will, you actually loses your right to benefit from that will,
Okay.
from any property of that will.
Of that will.
So an executor at times, if it is the legal practitioner that is actually managing the will, the executors, they don't even know that they are the executors of that will. And so when the testator dies, in the course of reading the will to the family, is then that the executor will know that I am the executor of this will.
Okay.
And now he follows the probate rules in order to execute or to share the properties as written in the will.
Okay, I just want us to handle some of these legal aspects before we get into the generalities of inheritance and the will. You spoke about having two witnesses. Are there any specification as per who should be a witness to a will? And do we have age limits? Can you take your child to be a witness to your will?
Normal, your child, you must be somebody of maturity,
Okay.
above the age of 18 or 21, depending on the legal system.
Okay.
Because each legal system has its own, each community, each country, they have their own age of majority.
Okay.
But in Cameroon, I'm sure it's between the age of 18 and above.
Okay.
So if your child is from the age of 18 and above, and the child signs the will, it is not always good that the child should sign the will, because a will should be something that is not supposed to be exposed
To the children.
to the children. because we have seen situations where wills have been stolen, parents have been killed because they come across their parents' will when the parents were still alive.
Yeah.
So it is first, it's not even good to first include your child as a signatory unless that child has loses his right to inherit from that will or from your property.
Wow.
Then you can include that child to be a
signatory to that will.
Yes, and the child should be of sound mind. You know, any individual who is supposed to be a witness to a will should be of sound mind.
Okay.
You know, it should be his free will to sign the will, not that somebody is forcing you to sign the will. And you know, above all, it should be somebody that can keep secret.
Okay.
Not that you go and sign a will and before they know it, everybody
everybody knows what is happening.
Yes.
Okay, thank you, Barrister. I'll let you catch your breath a bit. Let me talk to Tebo. Tebo, have you ever thought of writing a will?
No, I haven't. I haven't.
And do you have any reason for not thinking of writing a will?
I think that personally, it hasn't come through to me that I should. I mean, I believe that at a certain age you start thinking of a will.
Of a will. Okay,
Yes.
just hold it there. Let me get back to Barrister, because this is what I was expecting. So many persons think that you start writing a will when you are 60 years of age, when you are 80 years of age. But now I have the understanding that as long as you have a wish, you should be able to pen it down. So, Barrister, can you tell us how important it is for people to pen down their will as early as possible, if it is important?
Yes, first, it is very important to pen down your will. Why? Because you avoid all the... When you actually write down your will, it is important because all the administrative and court procedure, you avoid them. But if you don't write your will, first, the administrative procedure that they follow is different from a will that has been
established.
Yes, established. And when you die intestate, I want to first explain that before I go. When you die intestate, it implies that you die without leaving a will. And now you give room now for intestate. There's this rule, intestate rule, the Cameroon intestate rule, the intestate rule
to come in
will come in, and that rule, it gives the procedure on how your family or your siblings and your wife and everybody, they benefit from your estate when you are not alive, and they call it the non-contentious probate rule. That's what they call a non-contentious probate rule. It is incontestable because it is already stated. And from that rule, the first is the surviving spouse. Now before the children. And now it gets to the children are in three different categories. You have the legitimate children. That is the children of that marriage. The subsidiary, and then the illegitimate children.
Out of the marriage.
Out of marriage. And the illegitimate children, they inherit if they are being recognized by the father. Because there is a different process of recognition. You can have a birth certificate bearing your father's name, but your father has not
recognized you. Exactly.
So once the father recognizes you, you have a right to inherit. And then adopted children. Adopted children, they equally have a right to inherit. Because once you adopt a child and you are living with that child automatically loses his or her rights of inheritance to her biological parents. And so now the child can only adopt now from you. Now before you have now the parents, you know, the father, the mother, and you know the other sisters. And so if you write your will, you avoid this all those complications that it comes with intestacy. So you avoid it, and you equally avoid conflicts. When you pen down your will, you avoid conflict, because you know everybody will want to say, okay, this is what the person has stated down, and so I don't have any right, because it's his property, it's his wish. He has the right to distribute it in whatever way he wants. So he will avoid that conflict if actually a will is written down. It is also good. You don't only write a will to to know to distribute properties. You can write a will to say how
your funeral is going to look
your
like.
funeral will look like, whether they are going to incriminate your body, or they'll give part of your body to a teaching home.
Okay.
Yes, you can still write your will, and you say, if they notice that between 15 to 30 minutes that you are going to pass on, they can move your
some parts of your body.
Some part of your body, your vital organs, and
To
you give
help.
it out to charity. You know, so you also write a will based on that. You know, to say what they can do, how your funeral will look like. You know, and things, where they are going to bury you. You must not only have properties before you write
a will.
Yes, you
so
write
which
a
means that everybody can write a will.
Everybody can write a will, and many a times people don't write a will because they are not aware of the importance of writing
a will.
Writing a will. Many a times they are afraid. You think that when you are just writing a will, the next moment you are about to die. And then some people just believe that, well, if I die, family is going to sort it out. No matter how it is, family will sort out whatever, you know. And so on and so forth.
So thank you so much, Barrister. You have enlightened us on the importance of penning down your will. And I hope Tebo is here. Tebo says that he has never thought of the importance of writing a will. So I hope that by the end of this program today, Tebo will be thinking of doing one. Writing a will does not mean that you're dying the next day. Writing a will just means that you express your wish or what you want to happen to yourself and maybe to your properties when you are no longer there. Now, I want us to look at some of the life experiences that we have witnessed where there is no will. I know you have talked about issues of conflicts and the rest, but I just want you to, I don't know if you have had any experience or you have heard of any experience in a case where the parents are not there's no will. What happens to the family left behind?
I think that this whole issue of will, I think Barrister has articulated it so perfectly. I think that is still a big trouble in Africa.
Yeah.
And the reason why, before I come to your question, of course, there are a lot of families. And I think the reason why it is still a big trouble, first, people aren't accustomed to writing wills. And then secondly, there's this element of a successor, which is very important in Africa or in Cameroon, which is not very important in Western world. Because in most of our where we came from, our tribes and so on, there's this idea of a successor who kind of embodies or represents the mother or the father
when they are not alive,
to do incarnation on the behalf of somebody who is sick and so on. And most often, like in some traditions, when the father is no longer there and then the father did not leave away, everything that belongs to the father is owned by the successor.
Like the first son. Sometimes. You want to come in?
Let me come in.
Okay.
Please. Let me come in. That's the huge mistakes that we are making. It's true, it's the customary law that guides our various customs. And where you are heading from is the customary law. But again, there are statutory provisions. It's true, we have our customary, which implies that a first child, depending on the type of lineage, whether it is matrilineal or is patrilineal. But what you are saying is patrilineal. Where it is patrilineal, it's true, the first son can inherit. The first son will be the successor. But it doesn't cancel the fact that the statutory provision comes in. And when the statutory provision comes in now, you are the first son, you are the successor, but your mother is still alive. And when it comes to property, your mother has the first right to inherit from the father's property. So then you are just there as the custodian of that property. But the real person that has the right to share and to do everything is the mother. And so that is what I want to clarify here, because many a times when you go to homes, especially in the Northwest region, there is this conflict. You will see a successor will not want to even talk to the mother, because if they are blessed with a property that gives them small little income at the end of the month. The successor will stand
Want to be the one to control.
And
give orders.
Yes, and give orders. Forgetting that the mother is there.
Is there.
And it also depends on the type of mother. There are some women who will not even want to accept that. Especially if the successor is not responsible.
Exactly.
But if the mother discovers that the successor is very, very responsible, it now becomes their agreement. Okay, this is like this. You can go ahead and manage like this, like that.
But it's not like it is a right.
It's not like it is a right. It is not like it is like that. It is a custom, yes. But you can only gain that
with an understanding mother.
Yes. And you as the successor, you don't have the right to sell any property that you have inherited without the consent of all the other family members. You are just the head. It doesn't give you the right to sell. Because when you sell like that and your other sibling, they contest, you are going to go down for.
Okay, thank you. I think you should.
Again, Barrister, that is very correct, and you are talking within the ambit of the law. But we are living in it. What I think is that what ascertains in most of our communities, we live in a society where majority of Cameroonians don't even have access to this kind of knowledge of the money to start running around with court cases. Let me just take one famous family, the Fosso Victor's family. When he died, he left a will. And he left a clear successor and the property. But that way was heavily I think even now there are still legal battles in court. Just a few months ago, his children were fighting in one of his houses in Douala, and the machete came out, guns came out, they had to deploy gendarmes and so on. I think the battle is still going on. Now, because he had so many wives, legally married wives of course. So the other people, some people say that the will that was read, he was pressured by the daughter because the daughter was the one taking care of him in Paris before he died his last days. It was not the original will. So people had like 10 different wills. That Fosso Victor, I mean the late Fosso Victor, that came up. This that the one that the daughter, the lady who got married to one footballer, Jeremy Jita, because she claims that she basically owned most of the property that was left, and she was the person who was with the father before the father died. And she had majority, almost all the man's wealth. But other people are saying that one of the man's last son from the fifth wife or the third wife also has another will, which shows that he's the one who has most of the. All of these wills have been signed, or let me say documents have been signed. They said they are will. So in this kind of situation where we have contrasting wills, people, I have my own will, he has his own will, the wills have all been signed and so on, and then they are dragging the matter, is going from court to court, court of instance, appeal court, Supreme Court, and so on. What ascertain? I think that is where, because in Africa it's always going to be different. I think that in as much as what Barrister is explaining is an ideal situation, but in reality we don't have an ideal situation in Ashong. We don't have an ideal situation in Furawa. We don't have we have just some mama who is managing her life, which is a successor. That when the father is no longer there, they can say, well, they call him Papa. He can come when somebody dies. He can show his cup. They give his wine. So maybe they were not even married in court. I don't even know. I don't know again. What you are saying, is it about legally married wives or what is even legally married wife? A year, they say you stayed with the wife for 6 months, is legally married, you must have
No.
So this situation of inheritance, the wife is the first choice in case there's no will.
No.
Who is a wife in this case?
The wife that is legally married.
But in most of our villages, we don't have legally married women. Most of these
that's why
that's the challenge.
Is saying that.
Yes.
In as much as some of these customs are taking maybe a better part of us, when it comes to, like you are talking about having so many wills, and now you have to tell us how possible that can be. Yes, because in as much
somebody
as
forge a signature,
what happens? Is it possible that a single person can write many wills? Is it possible?
Yes, it's possible that you can write a will and a succeeding codicil, like to amend your will. When you write a first will, it is something that you are writing when you are still alive. And the world is evolving. Many things are evolving.
You're getting married to many wives.
Yes. And first, marriage is one of the points that revoke a will. When you write a will and you get married, that will is automatically being revoked, unless you had the intention when you were writing that will that you will get married. And you make provision for that. Yes, but if you didn't make provision for that, automatically that will be revoked. And so you can make as many wills as you can, but in the wills you have to state that this will it invalidate your former wills, and those wills now are some sort of codicil, and those codicil, they have their dates and they have their own clauses that have been stated on the codicil. And so now when they take those wills, they are supposed now to see how it evolved. They look at the various clauses, the dates and everything, and the signatures. But when it comes to falsifying a signature to a will, how do you falsify a signature to the will when the testator is still alive and strong? The testator must be the one to invite you to stand as a witness to that will. And you don't sign that will when the testator is not present. The testator himself also have to sign the will in the presence of those two witnesses.
Two witnesses. Now,
So the two witnesses will sign the will at the same time. And the testator will also sign the will in the presence of those two witnesses.
Barrister,
I'm just trying to
Yes.
come up with some kind of, again, I'm just playing devil's advocate. We are talking of, let me say I am I'm of age, I have so many wives, say 5 wives or 10 wives, and then I'm getting sick all the time. Sometimes I even lose memory and catch memory sometimes. My son from first wife came, and maybe
There are medical reports.
okay,
When you lose your sanity, the will that you write during that period of when you are insane is not considered valid.
okay,
They look at the wills that you wrote when you were at your best.
Okay.
That is, you have a sound mind. Yes, that is why it is said that a will is being written is a voluntary
act.
is a voluntary act, and you write when you have that capacity to write that will, and that capacity you must be of sound mind. You must actually know what you are writing. Nobody should force you to write a will. Like the fossil example that you are giving, while they were in Paris, that will not be considered because the daughter actually induced. He was under duress to sign that will. It was not his voluntary will to do it. They actually forced him to sign it. They will take all those wills and put together. All those wills, no matter all the faults and everything, they will take all those wills. And then the legal practitioners, they'll go
through it.
Yes, they use their discretion. The judges, they use their discretion. They put their arguments. The legal practitioner put their arguments to convince the court that within this time and this time, all of us who were seeing Fosso Victor, he was at his right frame of mind, and this will within this period must be his best and authenticated will, as opposed to this one when he was on his sick bed. When you are on your sick bed, at times they can force you to write something that it is out of your will.
Of your will.
Yes.
Now,
So,
let us look at, because now we just shared an experience of what happens. Now, what happens even when there is a will? If there's a will and you have people fighting and killing themselves, what more of what will happen if there is no will? Can you just paint us a picture, Tebo, of what can happen to a family when there is no will?
particularly a family that has a lot of money and properties.
Exactly.
Because at the end of the day, most often
it's about properties,
and money. I think that it can be messy sometimes, and we've seen it time and time and again, because again, this issue of writing a will is not really our culture. People have not really embraced it. Unfortunately, it is.
Yeah, it is what it is.
So when that happens, you see, because again, we are talking because we are in Buea, the court is next door, we have, some of us have gone to school, we know, we have barrister friends and so on. But majority of Cameroonians are not in this loop of discussion we are talking about. They don't settle dispute in court, they settle dispute
at home,
in
traditional
councils and so on, which applies different kind of rules. They apply old reasoning, they apply tradition, they apply precedents at their own local level, not talking about legal precedent per se, and so on to make this decision. And as a result, when a parent dies and doesn't leave a will, it opens a Pandora box of all sort of crises within a family. And most often from my experience, I've realized that most often it comes from a polygamous family. When the family is polygamous, because this mama is dragging his own children, your brother want to take everything, this one. Generally, from a family that from one mother, it is not that rampant. You don't see that kind, because when if the mother is still alive, it becomes worse even more the mother and the father is still alive. And when the mother is alive, you can gather the children, you can call them,
talk to them.
But in most cases that I have seen, like a recent another billionaire who died. It's a recent billionaire who recently died in Yaoundé. He's a owner of a chain of hotels in the country, South Africa and the rest. He had 3 wives. I don't know whether he left a will or not. But the fighting there was something else in Yaoundé. They had to fight his corpse even from the mortuary. The children of this wife were dragging the corpse. These other wives were dragging the corpse. Yes, so the corpse was falling down. They were carrying it and so on. So it was a total mess. And at that point in time, the will doesn't really come into force, because maybe they've not even read the will, that's just fighting just for burial purpose, and you say, no, I have the right and so on. So it becomes a little bit tricky. But on the contrary, if you look at people who were really married to just one wife, like Kaji, like the famous Kaji who died, he got married to just one wife. You see, he died. I don't know whether he left away or not, but the transition was so
calm. No, the problem with Kaji, I once listened to his documentary.
Okay.
Kaji is a wonderful man. He doesn't only get married to a single wife, but is actually somebody that prepared his family before his death.
He handed his property to his children when he was still alive.
And now this one manages this company, before his death.
This business.
But now it contradicts, what you say.
Don't hand your will when you are still alive.
Yes. There is a way to do things.
Okay.
There is a way to do it. Most families, they do that. You always organize your family meeting among your children, and you say, okay, I have this property here. You call your brothers, your kinsmen, they are there. This one is
belongs to you.
This one is your own. This one is your own. I will not give you property because
of these reasons.
I've given you 3 million and you went and squandered it. And so that's the reason why you will not benefit. But that notwithstanding, I'll give you my small car. Then you know that everybody already knows that you will not benefit anything from this property because of this reason. And now when your
that cannot be contested.
And now when your will comes now, when your will comes in, and they see the clause there, you give your reason. If you want, normally, because normal, all your children are supposed to inherit your properties. And so when you are writing your will, you have to make sure that you state each property that each child is going to benefit from. And if in case you don't want any child to benefit from your property, you give reason why that child will not benefit from that property.
So
and as such, when you want to contest that will, when they take it to court, the court will present it to you. Your father did not give you a property, but this is the reason. And it's a genuine reason.
It's a genuine reason.
Yes. And so it will minimize the conflict. It's true, it's very difficult to solve problems in a polygamous home. But if you are a polygamist, when we say polygamist, that is somebody that knows the rules, a man that has a strong willpower.
Yeah.
If you are a weakling, don't get into polygamy. Yes, but
because people will still suffer after you.
Yes, but if you are a man of strong willpower, that you can call your children and tell them, this is what you have, this is what you have, this is what you have. When you are no longer there with your will, it goes very quietly. The man you are saying is Foso Victor. The name you last
Kaji.
The Kaji Papa is even the sister's son that succeeds him.
Now, Barrister, let me just hold you there a little. Are you saying that children, they have an automatic right to the properties of their parents?
I say no. Okay. They don't have an automatic right because the properties belongs to somebody, and the person can decide to will his property to whoever
the person wants to.
Okay. And this is just the scenario I'm from explaining to you. That a father can decide not to will his property to disinherit his own child. So as property is concerned.
Giving you reasons.
Giving a reason. The father can decide now to will his property to charity.
I can remember
Yes.
my mother will always say that if you are not obedient, I will will my property to the church.
Yes.
She always said that.
Yes,
I will
yes.
will my properties to the
Yes,
church.
you know, you will your property to whosoever you want to will. It must not necessarily be your child, because there are some parents who actually suffer, and they have children. They don't care, and you see a child that is not even your family. You see a child that is not even related to you. That child takes upon him or herself to pass by and take great care of you. So if now you want to write a will when you are dying, who will you hand your property to? I am asking, because I'm just asking. Who will you hand your property to? A child that does not even know whether you exist, to a child that is waiting that when you die, that's when he's coming to pen the house and prepare the home very well for your funeral. Or to a child who makes sure that he comes around and make sure that you have water, you have food,
Exactly.
you have the basic necessities in life.
Exactly.
So,
and I think that
yes.
that takes us to our next question, which we want to find out, what should you take into consideration when you are putting down a will? Well, I know you have not started, but now at least we all have an understanding that it is important for us to put down our will. So
Exactly.
what are some of the things that you will take into consideration before handing properties to one person or the other?
Personally, I think that I would love my children to inherit my properties.
Okay.
You among the children, it's true that all of them, that your kids and you love all of them, but you want to look at the child that to an extent takes over you in terms of hard work, in terms of managing and gathering the family together, because you want somebody who acts as a unifier, who can rally people together, can unite them together, can grow and add value to what you've left behind. And most importantly, you want to also think of somebody that has that empathy, because we live in a society where people don't have empathy. People don't care about others, whether they are brothers, whether they are parents, they are siblings. They don't really care. And you want somebody who has a sound and an independent mind. It's unfortunate because sometimes the children are still small. You cannot really have a genuine assessment of how their decision-making process by the time they will grow up. But you want somebody who have a sound and independent mind, because this whole issue of leaving property or leaving a will to somebody, particularly a successor, we're supposed to gather people. You see, most often we look at people, you think that they are good and so on. You pick up one person, say you are
the ones they inherit power.
They want to inherit power. They get married to a woman who is not aligning with the vision, and you
Of
see
the
whole
family.
family. Yes, the whole family becomes very difficult. But there's something that there are two things that somebody told me, which is intriguing, and it was an elderly man, my best friend's father. He told me, he used to tell me that I used to be very close to him. He is of late now, may so rest in peace.
Rest in peace.
So he used to, in fact, like a father to me. He used to tell me that. So we used to discuss. Then he would tell me that if he's not, just talk that if he's not there, search will be Papa, search will be the father. Search by then, search was still, they were still carrying him. But he had a lot of children. My friend, the best friend of mine was one of his children. The second one is now in the army, one of his children, and so.
But he didn't call any of them.
Yeah, Search was just
the baby.
The baby. So he was saying that Search go be Papa, and finally, after when he actually died, that was the successor he left. And
wow.
so we just chatting. I was saying that okay, that's good. Then so that, and then I was like, but
why?
Yeah, because you don't know him. He's still a child. This and that. Then he would just laugh, and then he just say, no. I just didn't about Papa. Now what the name of Papa? Just like that. But after some time, as I was growing up, and then I started getting experience, people were saying, you see, this issue of will is complicated. You see, people pick people for different reasons for will. Yeah. It's because our parents used to tolerate a lot. I'm not saying that this case is the same. This is my best friend's case. I don't think it's the same, but somebody told me that if you go to most homes, 5 children, in reality 2, 3, they don't belong to the man of that house. And our parents used to know about it, but they kept those secrets and died with those secrets most often. So one of my uncles told me that is why at times you see a man who have 10 big children and he names somebody who's in the stomach as a successor. You cannot question it. And someone told me that if you go around, like in Boya, you see a house of 4 children, at least 90%, one of those children don't belong to that man. And it's true. No, that, again, it might sound outright, but that is why you see that there is panic. That is that there is panic everywhere. That's why you see that there is panic
in selecting who should I hand this
property to, because there is no just because you want to hand the property to somebody, you have studied the character
of that person,
and you are sure that this character can rally a family, no matter the other reason. There is no reason that you have children that you have known who are 30 years, 40 years, they are working, they take care of you. You name a 2-month-old child that you know nothing about to be a successor. If there is nothing deeper than what we know, I'm saying that of course it's a free wish, but it could have as well been his free wish to name an elder son,
influenced by something.
You've known that can study, can be encouraged to take care of the ones who are still small, who are still alive. Because at the end of the day, you want somebody who can ensure continuity of the family in unity.
Because there are families who have passed on, their parents who have passed on, and you look back at their family and you weep.
Exactly. That is why in most traditions they say that the first son is automatically the successor. Because they know that one has a higher probability to take care of the younger ones as they are growing up.
But on the contrary too, you see that sometimes when the parents die, the first sons or first daughters, they are just terrible.
First daughters, we are not even talking about women here for now.
No, I don't. And why don't that is? I was also going to that point.
Of course,
some people think that women should not inherit.
I was saying that they should not talk about women.
You have.
No, are
you gender biased?
No. What I'm saying is that in terms of successorship, not in terms of inheritance, those are two different things. Generally, when you talk about successor to a father, generally we're talking about men.
In those days,
there are women today
some people are
who are successors to their parents.
Unfortunately,
and they are striving very well.
Unfortunately, the people are trying to fight against that culture. I don't know the merits and demerits of it. But what I'm saying that generally, I think men naturally succeed their parents when they are no longer there. But again, some parents have to name women, which I think is still fine, depending on is their will.
There's a landmark case to the issue that you are just saying
in terms of the male and female inheritance.
You have this
or successorship. I think that's what you
successorship. Yes.
Loom and Furu or Loom vs Furu.
Okay.
Just Google that case and you read it. It's a landmark case.
Okay.
From the northwest region of Cameroon. Yes.
Right.
And there's
women they do inherit, and at times it's even the parents who appoint their female children as their successor.
Okay.
Even though it's somehow difficult, we are still struggling to accept that.
Yeah.
But there are parents who, among their children, they look like what you have just cited.
Yeah.
That a father will need somebody that will continue with his legacy in his absence,
or a
will
mother.
bring peace in his family.
Exactly.
So if the father has gone wrong and discovered that it is this my daughter that will bring peace in the family, and the daughter is not married, the daughter is in the compound, why would the father not hand the baton?
What if the daughter is
now
married?
You're talking about the daughter is not married.
What if the daughter is married?
Does marriage stop you from inheriting?
No, marriage doesn't stop you from inheriting.
Yeah, because I think that's one of the arguments that the men will always bring to the table, that you are not, as you see, she's not going to be part of this family for a very long time because she will get married.
Exactly.
And so she cannot carry my property to meet another man. But meanwhile, inheriting properties doesn't necessarily mean that you're carrying this property to another man.
I think that it's not just about property. When we talk about successorship, I think we are missing the point a bit. We're not just talking about property. Property is one of it, but we are talking about a successor to a family head. It has some traditional and cultural undertone,
which cannot be carried out by a married woman
from the official residence of that papa to another man's house. I don't know, barrister. Am I making sense?
You are a real culturalist, traditionalist.
No, I'm saying what ascertained in most of our culture.
Yes, that's true.
Okay.
Yes, that's true.
I think we should just move ahead to look at the negative effects of inheritance. We have talked about inheritance as passing over properties to maybe from the parents to the children or any other person. But now I want us to look at the negative effects of inheritance, especially when it comes to the children. I'll begin with you.
Okay. Some of the negative effects of inheritance are like it leads to family conflicts and dispute, as he has rightly outlined. You know, siblings they become rivals. You know, they fight, especially in a polygamous home, as we have just rightly. They struggle to challenge the will. You know, they challenge the will that, okay, Papa has not added my name. Why has Papa not added my name? Especially if Papa has not given a reason why your name is not added to the will.
Yes.
That suffice for that will to be revoked by the court, because you don't have any reason why you have not included a particular child's name in your will. So it is always good. It's a clarion call for parents.
Yeah.
When they are writing the will, they should make sure that they include all their children. And the ones they feel they have disinherited, let them state the reason there.
Right.
Yes. And then also financial irresponsibility or dependency, you know. When the negative, that's the negative, especially when the father was a very rich man, and then he has to hand the property maybe to an irresponsible child who is not even educated. That one will just go mad now. That one will just kill that child. You will see that child driving the car, even sleeping on the street.
Exactly.
You know, indulging in all type of wayward life that you can imagine. You know, and if it's somebody who is working, it leads to loss of work ethics. You will say, no, there's no reason for me to work now.
Yeah,
At least
I have everything.
I have money. So where am I going to? Let me just sit and I'm very comfortable, and then I enjoy my father's property. So there is no need for me to work. And so the question that I asked, now you are sitting without working. If your father never worked, where will you have had that property to inherit? And so if children want to sit and wait for their father's property to inherit, they should try and work their own, so that their own children
to also inherit what they'll leave behind.
Yes, I think that's.
Thank you so much, Barrister. You have really shared with us a wealth of knowledge this evening. Now we are rounding up with the program. Tebo, we have learned a lot. So what is your message to the younger generation when it concerns inheritance and the will?
I wanted to, before I wanted Barrister to clarify on something.
Okay.
This issue of creating a kind of a trust, I don't know whether that's the right term.
Yes, trustee.
Yeah, when because maybe our views are clarified. When you die and you leave children who are still very small, say underage. So what happens?
What happens?
Yes. You can appoint a child. I'm sure that question was given to you. So I was waiting to put in, but
we are just having few minutes.
Yes,
so
you can appoint your child as your successor, but with a trusteeship. That is somebody that you trust.
Okay.
And that trusteeship agreement should state that when this child attains this age, the property should be handed over
to that child. Okay.
That's the meaning of the word we are saying.
Okay.
I don't know if I've clarified.
Yes, I think it's
okay.
good.
Thank you for that clarification. And since you have had
your
clarity, you are very clear now on what should be done if you have a very young child. Not so. So can you just what message do you have?
I think that I want to thank Barrister for her very enlightening, educative talk and message this afternoon. I think it's very important. These are things that we should know and take them into consideration. And I think that it is now obvious that it is very important that we do the right thing, no matter how small it is. We can start from somewhere, pen down a will to avoid, because the world is evolving. We are not going to remain in the past as it has always been. We have to start doing things the right way to save everybody the stress in future when we are gone.
Thank you so much, Tebo. Barrister, I want to hear your last words on this topic.
My last word is wherever we find ourselves, either in our meeting groups, our community setup, we should try to enlighten our fellow people on the importance of writing a will. It is very important because once a will is written, it minimizes, it will not completely solve the problem, but it minimizes
the conflict
to a
in the
greater
family.
extent. Yeah.
Okay, thank you so very much. We have learned a lot. I, in particular, have learned a lot. And so our message this evening is that anybody can write a will. Writing a will does not mean that you're leaving us or you're going out of this world anytime soon, but it is very important for us to write a will. And when we are doing that, we should always ensure that our children are being stated in our will. And if you're not stating your children, I'm just getting from what Barrister said, if you know that you're not supposed to, you don't want to will anything to a particular child, it is good for you to state the reason why you shouldn't you're not willing any property to that child. And we should also note that a will can be changed. When the person is still alive, you can write a will today, and
Update
tomorrow
it.
you can always update your will. So it's not a static document. It becomes static when you are dead. Not so. All right, thank you so very much. Thank you for joining us on this program today, and we are pleading that you take another rendezvous to be with us again next week, Friday at 5 p.m. on Divine Mercy Radio Television. Until then, stay tuned to the wonderful programs coming up on DMR TV. I have been Fomucha Mirabel for presentation, wishing you a beautiful weekend. Bye-bye.